Hello and welcome. Today we're going to be talking about what is written discovery. And you're like, we're not talking about the Discover card here. Discovery. Sounds crazy. Or not really. Whichever way we're going to go with it. So yeah, we're going to talk about that because this is a big deal for people that are in litigation. Okay, and for most people, unless you're in litigation recently or it's going to be an issue, you don't know what this is, and it can be scary, and there's a lot of misunderstanding, and there's a lot of misinformation. So we're going to break all of that stuff down. If you're new here, my name is Taylor Darcy, where I help you create the business of your dreams. So welcome. I'm happy to have you here. I go live Monday through Friday, most days, at 11 right now, literally right this second. We're live, so that's fun. To answer questions, go over topics, things that are going to help you with your business, help you plan, help you make better decisions. And unfortunately, we have to deal with the things that are negative. And so that's why we're talking about discovery, because although it's not a fun topic, it needs to be addressed so that you understand the process when you're talking about litigation. So let's get started, shall we? Okay, so we're going to just talk very briefly about what the litigation process is, because there's a specific, not Pacific, sorry, I live near the Pacific Ocean, but I digress. There is a specific point at which discovery comes into play. Now, I was trying so dang hard to be able to show you what written discovery looks like so that you could see it, but that wasn't working. So I have to fix that. In future episodes, I'm planning on showing you stuff instead of just telling you about it, so that you can actually see what things are instead of it just being blah, 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 blah. I totally get that. So I am working on that. For whatever reason, it's not working, so I have to start over and figure it out. But anyway, I digress. So litigation is also known as a dispute resolution process, and it's done through the courts. There are mediation and arbitration, and those are different things that we're not going to talk about. Sometimes discovery is involved, not always. And what do I mean by that? It's not as extensive, and also it doesn't carry the same teeth as litigation discovery. So there's a lot to unpack on that statement alone, but just keep in mind that there are similarities between them, and there is discovery in almost every case that there's a dispute. So the first thing that happens in litigation is there's a complaint filed, and this complaint makes allegations. Doesn't necessarily mean they're true. And what do I mean by that? I'm not saying the person's lying, although that does happen. It may be what they think is true. And so, and there's another component to it. In complaints and pleadings, if you don't what's called plead it or file it in the complaint, then you can't assert that at trial. So sometimes you don't have enough information to make a strong argument for something, which is where discovery comes in, and we'll get to that in just a second. But that's the purpose of you file it in your complaint in order to make sure that it's possible that could be in. Now, there are parts of the complaint that you're going to be like, no, that doesn't fit. And a good attorney is going to recognize all the possible causes of actions, even if they're fluffy, even if they're not like 100%, because you might, in the discovery process, find those things out that fit those causes of action. Okay, so it's not that they're lying; it's that it's based on these facts, and it could be true if we obtain additional information, and we'll talk about that. So first is they file a complaint. Addresses the parties, addresses the venue, the jurisdiction, the facts, the causes of action, and it addresses the damages sought. One of the things that a lot of people don't understand, and this is something that I was actually reading, I'm on Quora, and this person asks, I have a legitimate wrongful termination case. Why won't anyone take it? And I mean, honest to goodness, it came down to money, because it wasn't worth the effort. It wasn't, they would have had to have taken it on a straight contingency case, and the damages weren't there, like, to justify that. And the party couldn't, more likely than not, afford an attorney. Now, that isn't guaranteed. This is just based on what we've read, and they don't always give you all the facts. People are shade the truth according to what they believe to be true. I'm not saying they're lying. I'm saying it's just that they shade the truth. It's like you can be in an argument with someone and you're like, was I really even there? I mean, really, like, because it seemed like we were in two different arguments, right? You're thinking one thing, the other person's thinking another. That happens a lot in litigation. Okay, so the first thing is a complaint. It alleges all of those things in order for it to be a good complaint. Now, it doesn't have to be a perfect complaint, but the better it is, the less likely the other side will be able to strike some things, get a demur, that type of thing. So then the other party has a certain period of time to respond, which is called an answer. And in that answer, they deny what's deniable, they admit what's admittable, and then, I know that's not necessarily a word, so please don't judge me on that. I'm simply saying that that's how that works. So you admit like what's true, you deny what's not true, and then you do what's called affirmative defenses. And the affirmative defenses are basically says, even if it's true, here's why this is also, like, why the other party isn't entitled to those damages or entitled to those things that they're alleging in their complaint. Or maybe it's a different thing. And so, and again, it comes back to, if you're in a complaint or if you're in a litigation process, the answer is a kind of a mirror of the complaint. So you're going to assert those affirmative defenses relative to those causes of action because you have to, because the pleadings require it. So otherwise, what ends up happening is if you don't plead it in that answer, yes, you can amend an answer, and there's all sorts of technicalities that go with it, but it complicates things. So the more thorough you are with that answer, the better off you are in the litigation process if it goes to trial. We're going to talk about why that might not happen. So first and foremost, so after you've filed all of these things, okay, complaint, summons, complaint, you have to serve it on the other party. They file their answer. Now you enter into what's called the discovery phase. And the discovery phase can be very short, can be very long. It really depends on the matter that the parties are working with. So if it's a simple breach of contract, discovery is going to be fairly minimal. You might have things. You're going to look at the contract. You're going to look at any correspondence between the parties. You might go into depositions. But what we're going to talk about is written discovery. And these are tools that you can use to hone your argument and spend less time with more expensive ways of doing things, because there's lots of different ways of doing things, but it can be very expensive. So written discovery is just strictly paper. So there's no, like you see on TV where they talk about depositions, that for an attorney that is trying to keep costs reasonable and not screw over their client and or take the right amount of time. If you do written discovery, then your need for a deposition, for a lengthy deposition, which there's limits to that and so on and so forth, decrease. And it's also less painful for your client, theoretically for the other side as well. But imagine those same questions that you have to do in written discovery that you do in a deposition. And without written discovery, how do you frame your questions in a deposition? Deposition being an oral, like similar to what you would see on TV with the court. Okay, so that's what a deposition is. So in written discovery, this is all paper. This is back and forth. The number one thing that I always use, or not always, but generally use, is what are called requests for admissions. What that means, I simply list I hone based on their answer, if it's a complaint, and or vice versa, whichever. I hone down and I get really narrow into those questions. Admit these truths, okay? And if you don't admit these truths, then what is the truth? And in that, they have to answer, and it's under penalty of perjury. That isn't to say that some people don't flat out lie because they think they can. Just true. I'm not. I know for a fact people have lied to me, like without a doubt. Like the facts simply don't match even close to what they said answer-wise. And so requests for admissions admit this, and then they go through deny. Why did they deny? They admit something, they deny something, and it's a long list of things that are you're admitting or denying. And so this helps you frame those arguments that you're going to use later on in a deposition, which is why they're so important. They're easy to, okay, I shouldn't say they're easy. They are easier to do and less, it makes your deposition much more fruitful. Okay, so that's a request for admission. Fairly simple, straightforward. The next is form interrogatories. And this is one of those ones that I wanted to show you that I can pull it up. If you Google it, California form interrogatories, it'll list the parties and it'll go through and it'll say, these details I need additional information on. Okay. And when you do that, it basically helps you, again, get information. That's what the discovery process is for, is getting information to prove your case. Both sides have to provide discovery. And you can't hide discovery. That doesn't mean that it doesn't happen, but you're not supposed to. Because there could be that damning piece of evidence that you see on TV. The discovery process is meant to suss out all of these details to show the strengths and the weaknesses of your case. Okay. And so it's a time-consuming process to draft these requests for admissions, to draft these form interrogatories. The form interrogatories actually can go pretty quickly. To draft them, to answer them can be a real pain in the butt. And depending on the party that drafts them and they request these things, you can spend a lot of time, hours, answering these stupid things. The good ones will only ask the questions that are relevant to the matter. And so that saves quite a bit of time. So those are form interrogatories. The next one is special interrogatories. These are like requests for admissions, but they can ask more detail. The difference is you can't, and the reason why a deposition is important is you can't ask follow-up questions with special interrogatories. But you can ask a ton of special interrogatories, relatively speaking, depending on the matter, depending on the case. There's lots of factors that go into it, so don't think this is unlimited. But you can ask a lot of special interrogatories to narrow that scope, to get it to a really well-done deposition, okay? And that's really what the purpose of a deposition should be, is a follow-up to the written discovery. If you don't do written discovery, your deposition is going to be way too long. And that's a strategy, but I find that it's not the best strategy because it allows too many options. It's way more expensive. I mean, like, infinitely more expensive. I can't describe it more than that. It's very expensive to do the same amount of work in a deposition that you could have done in a interrogatory or request for admission, so on and so forth. Now, that doesn't mean it'll absolutely be shorter, but the idea being that it can be is why you want to spend this time on. You can craft answers better. The problem is they can also craft answers better. So you can craft questions better and you can craft answers better. So it's kind of a, like it can be. But this is what you're going to face. If you're in litigation, this is what you're facing. That's part of the litigation process, written discovery, getting evidence to support your side. You're responsible for that, okay? You're responsible for getting your evidence from the other side. Those are special interrogatories asking more questions, okay? Different tools, different things, different limits, okay? The last and most common that you see is what are called requests for production. And this is where you're requesting all the documents that the other side has that could help your case or hurt your case. And you see them on TV where it's like this big box or this room full of stuff where you're just like, holy crap, it's just a mile high of boxes. And that's called a discovery dump. It doesn't happen very often, simply because that's Hollywood, and reality is those papers don't typically exist. Not that in that quantity. I mean, it obviously depends on the matter, right? The bigger the matter, the more likely that's true. The smaller the matter, the less likely that's true. So, but you have to list all of the documents, the things that you're expecting. I had a case that involved sound, so I had to give these sounds to the opposing party, and it just took time to do all of these things. This is not a short process. Discovery is meant not to wear you down, but to put all the cards on the table and say, okay, are you sure you want to go to trial based upon this information that both parties now have access to? And sometimes the answer is yes, because the other side isn't willing to settle. And then other times it's like, maybe not. Maybe this isn't the best thing. And so there's a lot of money that's involved in discovery, because that's where the bulk of the time is. Don't get me wrong, trial is very intensive, but as far as like long length of time, discovery is by far the most. The other part that discovery does, you see these, we call them Perry Mason moments in TV, where this one key piece of evidence comes at the very last minute and it saves the day. That's not how it works. In discovery, everything is laid out. And if you don't find it in discovery and you haven't done an MSJ for it, motion for summary judgment, there's what's called a discovery line cutoff. Everything has to be done in discovery at that point, okay? And so if you haven't done it, you're not going to be able to introduce it at trial. Just straight up. So this whole, last key piece of evidence thing that you see, that's not accurate, not true, doesn't happen. So just keep that in mind, that Hollywood isn't real. But so written discovery is a tool that's used, okay? And different attorneys will do different things on that. Some will help you answer them. Some will have you answer them and then modify the answers to correct for inaccuracies. Some it'll just be you answer them and that's it. It just depends on the attorney, depends on the case, depends on what the matter is. So there's lots of variations that go into it. The client is still, no matter what the attorney does, affirming under penalty of perjury that those things are accurate. So does it happen where the people lie? Yeah, it does. Do they get caught? Occasionally. Like, I've caught people in lies before when it was on their written discovery one thing and then in their deposition it was completely other. So it just depends. Like, and do I force that? I could, but there's other ways to handle that are less, and it's not about the confrontational. There are other ways to handle that don't equal a perjury charge that could just make things worse. So, but yeah, that's written discovery. Simple, straightforward. Don't want you to think again that the bulk of your case is spent in discovery, in the discovery phase. Written discovery is that subset of discovery that gives that information to be able to hone and get that deposition done efficiently, effectively, and saving time and money. Hours can be lost. doing discovery and answering discovery, because it's not just about, you have to understand that there's a little bit of tit for tat involved with discovery. The more onerous your attorney makes it on the other side, the more they're going to kick back and make it onerous on your side. So it can be rather painful just that's the truth. So yeah, that's the overall written discovery. If you have questions, leave them below. Let me know. I'm happy to answer them. But it's a large, I want to point it out like this. It's a large portion of the litigation process, but it's a small portion of the overall goal of it, right? Things can be won or lost in discovery by the way that the discovery is handled. So if you've gotten value out of this video, don't forget to hit subscribe and like, and know that we go live Monday through Friday, except for holidays. And stop by. Let's chat. Let's have a good time. Bye.